Okay, hopefully everybody had a chance to take just a quick break, and it's the testament to the engagement and interest in the visioning discussion that we had a slightly shorter break, but I think that's all to the good, and I think all of us have benefited from each other's collective and divergent wisdom and knowledge, and in some cases, and I'll at least speak for myself, just admissions about the holes and gaps in the legal literature, in the law, in complex litigation, about models and structures for design, distribution, and governance. So that's both a possibility and it's also a frustration. And I think a lot of what we talked about in the visioning discussion, at least, if not solves the problem, it teases out what our important questions are. So we don't have, a perfect model upon which we can export out to other public health crises, but we have lots of innovations and ideas to start for an opioid model, as well as a model that might export to other public health crises, both here and abroad. That is the topic of our last panel. And I'm sure all of you in attendance, your interests are obviously opioid focused for any number of reasons, but I think for most of us here, our interests and expertise and involvement extends beyond opioids and will intersect probably for the rest of our lives with litigation as a framework for dealing with health crises. Our last panel will be moderated by Professor Alexandra Lahav, who will introduce the panel, and I will turn it over to her.
Thanks so much. This has been so great so far. I'm really looking forward to a panel with really marvelous speakers. And I just want to apologize for my spotty camera. It's always when I'm at center stage that my internet decides to slow down. At any rate, the way we're going to proceed is that each of our 4 panelists is going to speak for about 5 minutes. And what I'd like to do is just introduce them as we go rather than all at once. And then we'll, after the quick, it's a pretty quick 5 minutes for each person. And then I'm hoping to open it up for questions and discussion. I'm sure we're going to have a lot of questions and for the panelists. So the first panelist is Professor Jennifer Oliva. Is that right? Did I get it right? Thank you. And she's the director of the Center for Health and Pharmaceutical Law at Seton Hall Law School. She also has an administrative position there. So she's a very busy person and super involved in on the ground opioids stuff. So take it away.
Thank you so much, Professor. Hopefully you guys can see my slides. Does that work? I cannot see anybody anymore. There we go. Okay, can folks see those slides or no?
Looks good.
Yeah. All right, perfect. So I'm here representing the state of New Jersey, and what I'm just going to try to do really, really quickly, and I'm going to talk really fast like I'm from Jersey because I am, is talk about a lot of the topics we've broached over the last day and a half through the lens of New Jersey. So New Jersey has a Senate Bill 3867. It's been passed unanimously by both houses in New Jersey, and it's sitting on the governor's desk waiting for us to go into our lame duck session, which starts the day after our gubernatorial election in November. Here's how this is set up. We've talked about this extensively. I'm not going to go into the first block, but states have lots of options here under the settlement structure. New Jersey opted for number 3, statutory trust. What goes into the trust? Here's the language. It's very, very broad. Here's the good thing about this language. It says that, all of these kinds of settlements can go into this trust, the Purdue bankruptcy, Malakoff bankruptcy, other things. It's not just the MDL settlement. Here's the bad news. The language is very narrow. In one regard, that's a mistake. I'm begging them to fix it. It says, litigation undertaken against opioid manufacturers and distributors related to all these things. So that would leave out claims against the chain pharmacies and folks like that. So that's an error in the bill that needs to be fixed. So I just highlight that here. It's broad, but I think that was a limitation that was unnecessary, and I don't think it was intentional, and that's why it's really important for us to drill down on our state statutory language. Supplementation versus supplementation has been discussed a lot during this event. Here we have supplementing language right in the New Jersey bill, which is great. Money is in the trust. You can see here, used only for the purpose of supplementing substance use disorder. Here's the bad. It's an annual state legislative appropriation. So the state legislature appropriates money to the Department of Human Services in New Jersey. Our Opioid Recovery and Remediation Fund Advisory Council is a 13-person council. It's top-down, state heavy. 3 members of that council who are ex officio are state officials, the Attorney General, the DHS Secretary, and the Health Commissioner. And then all the other appointments are made by the President of the Senate, the Governor, and the Speaker in the General Assembly. So it does say supplementing, but I caution people here that because of the entire appropriation to DHS, it's made by the legislature at the same time that they'll be doing this, that could get really fuzzy. What do we really mean by supplementing? Are they going to do like a FDA type thing where they like just cut the money back? I don't know. The language looks good, but I'm concerned about the structure. Okay, there's 5 express uses in the New Jersey bill. These sound good, again, on their face. I just want to highlight something here that I'm concerned about based on my background. Number 4, support programs that divert high-risk individuals from arrest and incarceration. That sounds good on its face. As I already told you, the Attorney General is one of the ex officios here. I'm concerned that will force a lot of money into drug courts and other programs that are problematic in New Jersey. The other issue here is that we don't have a specific allocation in our statute. So what we would do is default to the 15-15-70 structure that's in the settlement. And my state-specific concern is there's no allocation guidance among these 5 permissible uses. So, right, we could be really heavy on one and another one of these uses that may be better given what our infrastructure is like in New Jersey, may get less funding depending on how interest groups and lobbying and things like that work. I wanted to mention at the end here, my time is up, that there is an opioid settlement tracker. It's awesome. It's funded by the Soros Foundation. It's www.opioidsettlementtracker.com, and it tracks all 50 states and what they're doing. It's a great resource for folks out there. Thank you, and I'm sorry if I went over my time.
1 more minute. If you have anything you want to share with us in your extra minute, otherwise we'll move on to Teddy.
Teddy looks ready to go. I will hand it off to him.
So, okay, and we'll circle back to you, but that was fantastic. And I just want everybody to recognize the speed and compliance with the rules that we're seeing here. So, you know, everybody has a lot to live up to. All right. So now I'd like to introduce Professor Teddy Rave, who's a professor of law at the University of Texas. And Professor Rave is a man who needs some books. Oh, I'm sorry.
Maybe you could send me an autographed copy.
Yeah, exactly. So I just got a message. I may have mistaken. I have us as Jennifer, Teddy, Oscar, and Maria. Is that wrong? Is that what? Because I'm happy to switch it up.
I have something different, but why don't we just go with that?
And any order is fine with me.
All right, moderator's privilege. Okay, sorry about that. That was the end of Jen's time. Okay, so Professor Rave needs some books. If anybody's written anything great, I think they should send it to him. But in the meantime, please go ahead.
Thank you. And there's no way that I could possibly talk as fast as Professor Oliva, so you're going to get a lot less content out of me. So I wanted to talk just a little bit about the limitations of using litigation to address public health crises. The first limitation that I want to mention is that litigation is inherently ex post. So at our organizing call for this panel, Professor Lahav said that if you're inviting people like her and me to your conference, something has already gone wrong, like very wrong. litigation is not the place to avoid harm, right? It's the place to try to deal with the mess. Now, anticipation or fear of litigation and the liability that comes with it can, of course, have a deterrent effect, right? It can encourage manufacturers or distributors or doctors or other potential defendants to act more carefully because they want to avoid potential liability. But once we're in the litigation, that deterrent effect has failed. I don't want to say that the ex post nature of litigation is all downside. Litigation is responsive, so litigation can cut through political roadblocks. It can prompt action when other institutions are paralyzed. So in that sense, litigation has a sort of strong counter-majoritarian feature, right? People who can't get their voices heard in the political process can come to the courts. So I like to tell my students, this is America, you can sue anyone. And so courts are often the place to go when other institutions are not addressing the problem. And I think Judge Polster recognized this at his very first status conference in the MDL, right? Lots of institutions had failed: corporations, doctors, legislatures, regulatory agencies, others. And so the crisis was dumped in his lap. But that doesn't necessarily mean that litigation comes with the right tools to address the crisis. So Judge Polster said that he didn't want to have trials or spend time on motions on issues like preemption or the learned intermediary doctrine. But he pretty quickly found himself doing just that because those were the tools that he had. So that's one limitation. Another limitation of litigation is that it's rights-based, not population-based. And this issue came up a bit in the last panel. So litigation is fundamentally about remedying the rights of individuals who've been wronged, not about identifying the best policy for addressing or mitigating problems that affect whole populations. And so it's a very poor fit for public health, which, as Dr. Clark said, is inherently population-based. And I think that rights-based orientation really limits the remedies that courts can provide. So trials are good at figuring out who did something wrong and moving money around to compensate for past harms, but they aren't so good at designing forward-looking public policy. That's not something a trial verdict can really do. Now, settlement gets you a lot more flexibility. So Francis McGovern, who is the special master in the opioid litigation, used to say that litigation has a binary outcome. There's either liability or no liability. But in settlement, you have essentially an unlimited number of potential solutions. So the settlement designers can be much more creative than the trial judges can. And we've certainly seen that in the settlements that have emerged so far, right? They're doing a lot more than just moving money around to injured plaintiffs. But settlement depends on consent. Right? You have to get the parties to the litigation to go along with it. And note whose consent you need. It's the parties to the litigation. The drug manufacturers, the distributors, the plaintiffs who've sued. It's not the public health experts, not the community groups or people who've suffered from addiction, not the public in a broader sense. So that's a third limit on litigation. It's not democratic or representative like a legislature. A final limitation on litigation is that someone has to pay for it. And that someone in our system is the lawyers. And there's lots of advantages to that, right? So private lawyers aren't limited by the same political constraints that public enforcers might be. But once private lawyers have invested in litigation, they're going to want to see a return on that investment. And so you've created another stakeholder at the table. And a pretty powerful one at that. They're going to want to get paid, and they're going to have to get paid if you want them to play that role. But again, the plaintiffs' lawyers are not a democratically representative institution, right? Their interests are not in designing the best public health response. Their interests are in getting the most money for their clients so they can get the highest contingency fee award. So maybe dealing with public health crises and litigation is sort of like Winston Churchill's take on democracy, right? It's the worst solution, except all of the others that we've tried from time to time. So I'll leave it there. Thank you.
Thanks very much. So I'm going to now ask, because we're still in the realm of litigation versus other alternatives, I'm going to actually ask if it's okay with the panel, Professor Glover, who really needs no introduction, but she is a professor of law at Georgetown. She's also the mind behind this interdisciplinary conference. So if she could make a few remarks now, and then we'll turn to the international broader angle with Professor Cabrera. So Professor Glover, take it away.
Yeah, so since, we're sort of constrained on time in terms of how long we're going to talk, I love that Teddy's ending was actually my scripted beginning, which is, democracy is the worst except for all the other alternatives. And so if we're thinking about creating a model within the litigation structure for opioids, but more broadly, and Jose's going to take us sort of globally with this, what can litigation do and what can't it do, as Teddy so eloquently laid out? We have to think about why in the world we're even doing it this way and what the alternatives were that we either considered and rejected or that we just don't do. So in the United States, the American approach is pretty unique to regulation with some notable exceptions. For example, the FDA and approval for pharmaceuticals and biologics. The predominant approach to regulation is ex post. So, if Teddy and Alexandra and myself are getting invited to conferences, Teddy's right, something bad has already happened, but that is not a bug, that is a feature. Our predominant approach to regulation in the United States is ex post. We are a consequence imposing regulatory system, not a preventative system. As one scholar put it, the United States regulates consequences, not market entry. It's also unique, the American regulatory approach, in that it entrusts somewhat uniquely this ex post enforcement of laws, not to agencies, not to public interest groups, not to state legislatures, not to any governmental entities, but rather a diffuse set of private regulators who are basically private citizens or in the opioid litigation. They can be cities, states, and municipalities, but generally the government's taking a hands-off approach and has created a diffuse enforcement system. And that has many consequences. It means there's all sorts of opportunities for private litigants, as Teddy said, to sue anyone, but it also places a great deal of responsibility and pressure on attorneys and judicial officers to essentially bear the yoke of regulation in the United States. So just as an example, the Fair Labor Standards Act for wage theft, that's technically entrusted to the Department of Labor. Congress doesn't fund it, hasn't funded it meaningfully for years. They have the resources to pursue less than 1% of wage theft claims. Employment discrimination is the same thing. 2% of employment discrimination complaints are pursued by the Secretary of Labor and the Department of Labor. 98% by private parties. As a normative matter, that's good or bad depending on some of your priors and specifics about the particular cases. So sometimes private parties are more direct stakeholders in the harm than are public entities. They tend not to be politically captured. They might be closer to the facts. Our adversarial legal system is nothing if not monetarily incentivizing. And attorneys and private parties sometimes tend not to be subject to capture. Again, that depends on the case. And in opioids, we don't have necessarily all the advantages that are sometimes pointed to for using private enforcement as a mechanism of regulation. But I think it's critical to understand that when we're talking about forming models nationally, we're operating within this overall regulatory structure whereby most enforcement is entrusted by design to private parties. And there are different theories for that. One of them is the blame deflection theory that Congress and other governmental and elected democratic actors do not want to do this because they don't want to be responsible for it. There's slack minimization theories, all other theories, but fundamentally, I don't think we can expect that the American regulatory system is meaningfully going to change to a bureaucratic, ex-ante-democratic regulatory system to one from one that is ex post and relying on private enforcement. And for other countries, then that raises a tough question. Do we want to be like America? How well is our bureaucratic setup working? Germany's very much set up like this. So when we're talking about models for opioids, we're not just talking about a litigation model because it happens to be in litigation. We're talking about a litigation model because, of course, it's in litigation, and that's where other public health crises are going to go. And I hope other countries can sort of draw from our experience as well as other alternatives to think about their models. And one specific point with regard to regulating through private enforcement here, drawing on Teddy's point that, it's not democratic. This doesn't represent people struggling with addiction or their families. It represents the parties, the drug manufacturers, and then the states and municipalities on the other hand. And one irony of this particular litigation is that among the reasons we're in litigation are all the general ones I expressed, but also that there was very open and expressed distrust on the part of the states that the state governments would handle this appropriately. And now we're in the ironic situation where the litigation has been brought by those states and municipalities and is generating settlements that places design and distribution responsibility back in the hands of the entities that the municipalities and state attorneys general sued in order to avoid. So there's lots of interesting pressure points here with opioids in particular. But as we broaden out to a model of an opioid distribution and design, we have to take into account the regulatory apparatus in which it exists, which is almost exclusively reliant on private enforcement and all that entails. And then as we think globally, which is the next part of the panel, how well this would work depends on a lot of your answers and normative priors about entrusting to private parties and private enforcement the regulation. Now, this is not compensation. This is regulation. We are regulating a public health crisis through litigation because that's how it was designed. And whether we export that model or not depends on the answers to some really tough questions about structure and alternatives. Hopefully, I am not over time.
Thank you so much. And now I'm gonna turn over the mic to Oscar Cabrera. I'm delighted to introduce him. He's the program director of the Healthy Families Initiative at the O'Neill Institute and a visiting professor at Georgetown Law. So take it away.
Great. No, thank you very much for the invitation to participate. I'll try to speak fast, but definitely not as fast as some of the previous speakers. I had structured my presentation just kind of to give some context of how litigation has been used in public health crisis, but kind of to regulate risky commodities throughout different set of jurisdictions. However, kind of hearing like Teddy's and Maria's presentation, I'm just kind of adapting a little bit because two of the elements that I wanted to bring to the table was the role that litigation can play outside the US to do ex ante, to kind of push regulatory agencies to act. So I'm gonna briefly talk a little bit about that, but then that we see a much more active role. This is more from the context of constitutional theory and the democracies in the global South, Latin America. Courts play a much more active role in that process of policy making. That's the whole idea of deliberative sort of democratic processes, right? So it's not as restricted as it might be in other contexts. And one other comment that I will make before I get started with the 3 points I'm trying to make in my short remarks is, I'm not necessarily thinking of public health crisis. I'm just framing this around how can we use different branches of government to move towards regulating unhealthy commodities, risky products, that all of that frame under maybe a little bit of theory of risk regulation. So we, of course, have ex post litigation, healthcare recovery cases that have been litigated through our region. There's one case now being litigated by the Brazilian government to try to kind of recover costs that were associated with tobacco use, suing directly tobacco companies. So that's more similar to tobacco litigation in the US. Of course, those cases have their own complexities. I think here, even if it's a liability case, it's really grounded on rights and constitutional rights and collective rights, not just individual rights. So understanding the right to health is one that goes beyond that individual entitlement that may have collective sort of dimension. But we're starting to see also courts being used to push regulatory agencies into action. This is not 100% prevention because we already may see some of those products permeating the market and getting data on the negative impact they may have on health, for example, if we're talking about ultra-processed products or products that are high in critical nutrients like high in fat, sugar, and sodium. So there's litigation to try to push courts to give a direct mandate to a regulatory agency or to the legislature to try to enact specific policy interventions, especially when we have enough data or international standards to try to connect with what are some of the best buys? How do we regulate these products to minimize their impact they have on society? And this connects with another point that that we do have in Latin America. I remember my first month at Georgetown in 2008. We're having a discussion. I keep bringing this idea of inconstitutionality, violation of the Constitution by omission, right? Inaction on the part of government can lead to inconstitutionalities. And I think that's foreign to a lot of people that see the Constitution are just imposing sort of negative, sort of right restrictions on the government ability to act. But we've started to see that a lot emerge in this space. Inaction on the part of government violates constitutional rights. So we see courts mandating regulatory agencies or legislatures to specifically enact public policy and sometimes even direct guidance on what is the evidence, what are the standards, how they should go about enacting this type of regulatory interventions. And this connects with the last point that I wanted to make, which is that we do see an emergence, and this comes from the business and human rights space, but from the overall idea of corporate capture of government and courts being much more open to evaluate inaction on the part of government, especially when we know that a lot of our governments are co-opted by private actors, right? Or that by actors that have private interest in hand and not necessarily the public interest. So in that space, we've seen kind of at the international level, standards are starting to kind of evolve, for example, to understand corruption and not just the traditional way we understand corruption, but when the government is captured by corporate capture, that's kind of the concept that has been used, for example, by the Inter-American Commission on Human Rights, and that leads to inaction and not regulation. That is a new form of corruption. And in that context, courts are a little bit more open to try to push government for action. And the last piece, because that's just kind of reacting to one of Jeff Teddy's comment, which is in a lot of countries in the global south, sub-Saharan Africa, countries that I work on, like South Africa or Kenya, or countries in Latin America, we do see social rights are being more collective. So there's that set of constitutional rights that are not just totally individual. So you could claim a collective broader remedy, even if you're using a rights-based sort of framework. But I'll stop now so we have more time for discussion. I couldn't see the little posted. I hope I didn't go over time, Alexandra.
No, I was just giving you one more minute. That was supposed to be my 1 minute warning. It's very analog. But actually, if I could, so first of all, I'd like to solicit questions from the audience. But to start, I actually want to ask both Professor Cabrera and Professor Rave about the and maybe Professor Glover as well, about the individual versus group issues. So Professor Cabrera, you noted that in other countries, I know particularly the South African Constitution actually recognizes group rights. And as a comparative matter, I'm not a comparativist, but nor do I know really anything about the Constitution anymore. But I do have a sense that in the US, since at least the 1960s, we have had increasing recognition of the idea of group rights and group litigation. So I want to push back a little bit against Professor Rave's individualistic characterization of our system. And as a matter of fact, though that may not be normatively, he may think it's normatively problematic. So I was hoping that, maybe we could turn to Professor Cabrera first, talk a little bit more about the concept of groups and how you think it might relate in the opioids context or other public health litigation emerging in other countries, and then maybe turn to Professor Rave to respond to my challenge on the individual versus the group. So, anybody else on the panel who wants to chime in, absolutely, please do.
So I mean, this is think there's a lot that we could discuss about this particular issue. I think there is the specific sort of one, for example, emerging, that started in Venezuela before kind of rule of law kind of issues post 1999 Constitution of Venezuela, but we're seeing this in other countries in Latin America, to argue that even if they're individual rights in nature, the right to health being a right holder is the individual, duty bearer is the state, it's the fulfillment of that right requires collective action. So that's one, it's an individual right, but I need collective remedy to be able to fulfill, even if it's an individual right. However, there are other rights that are now considered more collective, that I mean, even the right to health in other countries is considered to have that broader dimension, not just my individual entitlement to get access to health services, but also the preventive dimension. I need to be able to live in a healthier society, and that could be perceived as a more collective right. But one piece that I think I want to highlight on the more collective groups is issues around standing, and how we have seen a lot of flexibility in who has standing to try specific actions, from NGOs that may claim their own standing, and we've seen that kind of evolve in a lot of countries, but also this idea of collective and diffuse interest, that members of society as a whole may have an interest in a specific issue, even if they don't have a legal right or entitlement to get that, because they're part of society. So that has also opened the door for kind of more experimental sort of type of litigation. There are cases, emblematic cases are in Colombia, in which on environmental cases, they were even able to declare that a river had like a legal persona and then it needed protection. And I think there's some, that idea of those group sort of rights, but that's more on the procedural side of on standing, and how that has opened the door for more creative litigation. So I'll just stop there with those two points.
Great. So now if Teddy, if you'd like to respond and maybe say something about the standing issue, but I also want to raise for you to respond a question that was brought up in the chat, which is this idea of that you raise of rights-based versus population-based. And how does that jive with the substantive claims that we're seeing in some of these cases, especially the expansion, or I don't know if you want to call it expansion, but the use of public nuisance. So please, what do you think?
Yeah, so so maybe thinking about it as individual rights-based versus population-based is like too stark a dichotomy, right? And I think Adam Zimmerman is correct that the idea, the substantive remedy that you can get for public nuisance is probably blending those two features. Though I do think that, and you mentioned earlier that there could be a normative question of whether we should focus on individual rights or group rights. I think I'm probably on your side on the normative take. I think it makes a lot more sense to think about these rights as inherently group-based. But I think that doesn't fit well with our sort of inherited legal system, and a lot of the sort of innovations that you see sometimes in the substantive law, sometimes in constitutional doctrine. So think about lots of issues that come up in election law, or sometimes in sort of the procedural tools that we use to deal with mass litigation are fighting against that sort of instinct that courts are about remedying individual rights. And so I think we can see that in standing doctrine. We can see that in some of the class action doctrine, which makes it very hard to find that common questions are predominating, because we can and privileging the right of individual class members to opt out, or to have a particular state law apply to their particular case to assess particular specific causation, instead of looking at this sort of like more functionally and group based. You can see it, I think, in multi-district litigation. So multi-district litigation has this sort of fiction that everyone files their case in one court, and then they're temporarily transferred to the Northern District of Ohio for Judge Polster to manage pretrial proceedings, and then they'll go back and they'll have trials where they were originally filed. And the MDL judge, like Judge Polster, can get away with a lot of innovation, because we're pretending that these are really individual claims that are going to go back. So I think there's a tension there. But I also think that our kind of I'll call it sort of inherited legal system puts real constraints on how creative you can get with a remedy. And even with a substantive law like nuisance, where abatement could be part of the remedy is still tailored to the parties who are there. And so you can't look at the whole population. You look at the parties that are in front of you. So I think the U.S. system in that sense is very different from many other legal systems that are far more open to things like group rights and positive rights, claims against the government for inaction. That's not normally a winning constitutional claim in the U.S. Yeah.
I'm wondering if Professor Glover, do you have any comment you want to add at this point? Because I have one question for Professor Oliva, if you want to just give us your 2 cents, and then I'll ask my question.
No, I'm great. And in fact, I'd really like to hear more from Professor Oliva. I think New Jersey is such an interesting, hitting the ground running model. So I'm going to yield.
So I'm wondering, and this is a little bit about New Jersey, but also about comparative angle between states. So, Professor Rave mentioned innovations, right? And in the, we spent a lot of time focusing on the MDL, because we're, at least Teddy and I, because we're MDL scholars. So, that's where we see a nail and we're like, I got a hammer, let's go, right? But I'm wondering if you could talk a little bit about what you're seeing from your perspective, maybe across states, or how we should think about these innovations and the relationship between the central and the decentralized approaches, either to governance, to this kind of question. Like, what's your perspective on those, on specific state things as compared to a more general federal approach?
I think it's a good question, and I hate to bring up COVID, but there's been a lot of debates in the public health space about federalism, and is the 10th Amendment killing us right now because we couldn't have coordinated responses across the states for a problem that obviously is across the states, like a contagion. That's the same issue here. New Jersey actually has extraordinarily powerful home rule for counties and municipalities. So this very centralized approach is really interesting. It's going to be really important. I know folks have brought up the money. The only state, I did a back of the envelope, and maybe you or Teddy or even Maria may challenge me on math. I'm a law professor because I'm not particularly good at it, but the only state that is getting more money than the plaintiff's lawyers, and that's only if everybody signs on. Okay, this assumes best case scenario is California. California will get slightly more. New Jersey at 2.76% will get $600 million if the Attorney General on his county by county tour that he's on right now is successful in getting everybody to sign up by January 2nd. So that's where we're at. So New Jersey has taken a very centralized approach. I think it's going to be very interesting. I think there's going to be a lot of fighting about who gets put on the panel, right? Gets put on the advisory board. I think Maria brought this up in the last session, and Shelly has talked about this extensively. I'm very concerned about the advisory board and how much power they will have, because they are purely advisory here, and they're purely advisory to one agency, DHS, and they're all state nominees. Now, I'm sure they'll come from different regions of the state. So I'm very interested to compare this very, very centralized approach in New Jersey to states like, I think people have brought up Arizona and some other Western states where there are a lot of county state MOUs, and that approach is being used, a much more decentralized approach. So which structure is better? I don't know. It may depend on what your allotment amount in your state is, what your infrastructure is like in your state, how powerful your central health administration is in your state. Is that mostly county by county, or is that mostly done at the state level internally in your state? So it is all over the place. It's wild. I think that the best approach for a state is to use a structure that best reflects its public health infrastructure, right? So how is that done? Is that done on a county by county basis, or is that done in a more centralized fashion. And in New Jersey, we've picked a centralized approach here where our public health infrastructure is actually regulated mostly at the county level. So that may become a really serious tension going forward.
So I have a follow-up question, and this is actually inspired by a question that Adam Zimmerman has put in the chat that's directed at Oscar and Maria. So if Oscar and Maria could start thinking about this very challenging question. From your perspective, how do you see the political economy aspect of this playing out? So here's, and I come from a place of ignorance, so I hope you'll educate me and forgive me. But it strikes me that in the US, some states have robust public health infrastructure and other states really don't and have a very weak public health infrastructure in the state. So it's not really solely a question, well, or I guess my question to you is it really about decentralization or centralization, even when we're looking at the state level? Or are we also talking about other political choices not to invest in public health that are then going to be recreated in how the settlement is paid out? Or is decentralization always not going to work out? That is every state that's good on public health also centralized? I hope that question makes sense. It may have multiple parts, but any reaction that you have, I would really welcome.
I'll say one quick thing, and then I'd really love to hear from Professor Cabrera, but based on, and he had to leave a few minutes ago, but based on, and I'm speaking not as an expert, Zach Talbot will be the expert here, but I do work with Zach's recovery centers and others in Tennessee and in the Southeast region. And our observation is not necessarily that public health infrastructure necessarily tracks or absolutely requires centralization. I think at a minimum, what we're observing is, these primarily red states who have opted out for political reasons of federal funding and Medicare and Medicaid funding. That makes, it doesn't matter, right? If you have the funding from the settlements, if there's not the infrastructure for folks to get treatment and the things that the settlement funds might contribute to. And then there's an additional issue, which isn't just public health infrastructure, but it is what is available and not available as a matter of treatment. So my understanding is there are three key, Suboxone methadone treatments for substance use disorder, but they're not available uniformly and comprehensively in various areas. And so we get statistics showing that this medicine works better for this group and that medicine works better for that group, and this group has access to this, and therefore they need this or they're not getting this. And the reality isn't so much that certain medicines work better on certain racial groups or certain genders, it's that geographically and under the structures of their state or their region, they just are not given access to those drugs, given all the decentralized and diffuse contracts with insurance companies. So I think centralization could certainly help with in those respects, centralizing what's available, general contracts with the providers, and also, general approaches and centralized approaches to recovery, treatment, insurance coverage, Medicare and Medicaid. I don't think that the health apparatus has to come from the state. It doesn't have to be NIH. But we are seeing in states that tend to have what I think are accurately called more regressive approaches to public health, health access, treatment access, and coverage for treatment. It's a really open question to us. How can we even operationalize so much of what needs to get done against the significant hurdles and impediments that exist in some states?
Oscar, do you want to jump in? And then I'd like to hear a response from Jennifer as well.
Yes, I'll jump in, and this is a question on the chat. I think these are processes. I mean, the ones that we know of, that we study, that were sometimes engage in, they do happen in parallel. I don't think it's just abandoning one versus the other, but activists tend to work on multiple fronts, right? And when the windows of opportunities are there with executive branch of government, you pursue that. When it's in the legislature, which is a longer process, you pursue that. But litigation in courts, and I think that's something we've seen change in the past 10 years, for example, in Latin America, use more creative ways to really incentivize change, to try to get different actors in government to kind of, just to steer them into action. I think it's complex at times. I mean, I think one case that comes to mind right now, it's in the context of regulating ultra-processed products and warning labels on products. And right now, for example, in Colombia, you have the three processes happening in parallel: a regulatory process, a bill that is being debated in Congress, and a case that could kind of also give specific mandates on this. So I think in our region, and now I'm talking about Latin America, given the political sort of instability of executive branch of government, I think activists tend to bet on putting a specific work in all lines and not just on a legislature, executive, or litigation exclusively. But that has also meant that in courts are being a little bit more creative when it comes to remedies and when it comes to what type of issues they could like a mandate through judicial decisions. So I see it's a combination of factors, because if we look at other countries in our region, they're completely working with the legislature 100% or with executive branch of government. So it depends on the context specifically. And one last point that I wanted to tie with a previous comment that was made is, I mean, we do have cases of liability, and that's like, how do we absorb externalities? How do we use courts to try to kind of get companies accountable in this space? However, this is a very costly and lengthy litigation in a lot of countries in our region. I'm talking about over 10, 15 years. So the ability to maintain that type of kind of resources and pressure just to get a specific result out of that, it's not always as successful. That's why, in turn, what I've seen more used as a strategy is constitutional-based litigation. That tends to be more expedited processes. They tend to be short. They tend to have less sort of strict evidentiary rules. So like procedural rules are more flexible to try to benefit the plaintiffs. So I think there's something there that we're starting to see. And in a couple of countries, we're starting to see litigators, activists experiment with that idea of corporations violating constitutional rights, so therefore using those type of expedited sort of constitutional type of litigations.
Thank you so much. That's so helpful, and I think we're all curious to know more about these other models. I was just hoping to circle back to Jennifer for a minute about about this same question, the political economy question, and then we also have Zachary Talbot. Has had I think might want to weigh in as well. So let's start with Jennifer, if you could.
Thank you so much. Yeah, I think this is probably going to sound harsh, but people have said it in more diplomatic language who aren't from New Jersey throughout the last day and a half. We're really expecting an extraordinarily flawed, underfunded, broken, and disparate public health infrastructure across states to sort of save us here, and it's a huge problem. Maria alluded to this when she talked about access to like the non-controversial gold standard treatment for opioid use disorder, methadone, buprenorphine. Let's face the facts. The state of Wyoming doesn't even have a methadone maintenance clinic in the entire state. These are highly regulated by the federal government under the Controlled Substance Act. There are a lot of requirements, et cetera, et cetera. 9 state Medicaid programs will not pay for folks to get methadone. This isn't going to be fixed by this settlement agreement, okay? West Virginia, which is one of those 9 states, which has been hit very, very hard, has a moratorium on opening new methadone clinics. We're not going to get around NIMBYism. We're not going to get around the long stigma that has existed here. 3 states very recently, we've heard a lot about syringe programs, and I had the pleasure of writing something with Shelly about this recently, including my state of New Jersey, are enacting legislation or repealing the right to operate syringe services programs right in the midst of this. So I just want to emphasize that I think that we're looking we're hoping too much from a really broken public health infrastructure. It's better and worse in some states than others, but it's worse in the states that have suffered the most throughout this crisis. I mean, in some ways you can make a fairly strong argument that the states themselves are negligent here, and the states have contributed to the crisis that's gotten progressively worse here by implementing policy after policy after policy that has exacerbated the problem instead of made it better. So I am a pessimist here. I'm very concerned about the states that are heavily reliant on attorney generals and a criminal justice approach. We're even seeing a little bit of that in the very blue state of New Jersey. And I think you're going to see a lot more of that in the Midwest and the southern states. And I will turn it over to Zach because he knows a ton of stuff about this.
Yeah, I'd like to hear from Zach Talbot, and I just want to say I could talk to you guys forever. It's so fascinating. So, Zach, can you?
Sure. I'll. Sorry, I don't have video. Yeah, sorry, I don't have video today, y'all. I was going to build on something Maria said, but now my brain's gone in a bunch of different directions. So I'm going to make a couple of small, quick points that I think may be helpful. One I put already in the chat, that we have to also remember that even though state Medicaid plans are federally mandated to cover all of the medications for OUD, currently that's not forever. And so we have to really consider, because like states like Tennessee, where we had some prescription buprenorphine Medicaid coverage prior to the Support Act rolling out, come I believe it's 2025, states could technically, that mandate ends. And so we may lose the Medicaid funding that's been critical at present, but also the states, you make a good point that West Virginia is the only still a state that doesn't have an opioid treatment program. I would encourage us to relegate the term methadone clinic to the dustbin of history, since the vast majority of opioid treatment programs offer at least two, if not all three, of the FDA approved medications. And also the medications are just one little slice of what opioid treatment programs do. So that term alone can conjure up some stigma unintentionally, perhaps. But we've got to kind of think that we could be headed towards, for lack of better terminology, a relapse from our progress that we may make over the next years if suddenly you have states that just start cutting funding for these services again because the federal mandate ends. So we have to, it's very nuanced. And then to Maria's point about different states, I think Georgia has shaken up the notion of a red state versus a blue state with, but largely states that have more, I guess I would say, conservative governors in those state administrations. We are seeing, just a lack of, for budgetary reasons and other things, like in Tennessee, again, for another example, they've tried to do the Medicaid block grant, which would substantially limit. And then the block grants themselves, the way they come down, the way the federal money comes down, which I talked about a little bit yesterday, it's very nuanced. And so hopefully we can break out of the same old, but we are kind of putting this all back to the states, which is where, unfortunately, a lot of the current problems reside.
And do you guys, the panelists, and maybe, Zach also, is there something useful in litigation in this way? So, the original question that prompted this conversation, this part of our conversation, was a question about the political economy of litigation, in that it does allow some groups who might otherwise not have a voice to bring lawsuits, and especially in situations that Oscar mentioned, where you have your more expanded standing rules, you might get players who otherwise are not enfranchised. Environmental groups in the US is one thing I'm thinking of, that could have a voice. So in this situation where the states in the US have let people down, or maybe in the transnational context, does that militate? Is that sort of I don't know what the right word is, like a check in the box of litigation, that it can have a role or not? And I see Zach is saying, even then you have to have private resources to take action. Teddy can talk, I think, somewhat to the deployment of the private resources, but I'd love to hear reactions from our panel. And if the panelists could just signal me in some way. My camera stopped working, but I'm watching you all avidly. So if you could signal to me, I'll call on whoever signals first. Oh my God, it's like class, no volunteers.
I'll
right,
volunteer.
Teddy,
I'm
you
not
go
sure how to
first,
signal you.
And then I'm going to use my prerogative to call on Oscar, if that's okay with you, Oscar. Go ahead, Teddy.
So yeah, I think this is one of the big potential strengths of litigation, right? When you've had failure at say the federal regulatory level, you've had failure at the state level, I don't want to suggest that there's not a political economy to litigation, because there definitely is. But it's a different political economy than the one that would prevail at the federal level, and the one that would prevail at the state level, and the one that would prevail at the local level. So litigation gives different interested parties an opportunity to draw attention and really, throw a wrench in things like, hey, this is a problem that you need to deal with. So it can definitely do that, right? It has a big sort of attention-getting function, and as I think I said before, like a counter-majoritarian function. People who are shut out at other levels may find a foothold in litigation. And Zach Talbot mentioned in the chat that well, even then you need resources, and you definitely do. And that, I think, is where the private lawyers can play a big role. If there's money for them to recover in litigation, then they have a big incentive to go out and look for wrongdoing and bring cases and shake things up. And that's also, that tends to be, people don't necessarily like that at the end. So we've heard a bunch today and yesterday about how much the lawyers are making. I think Professor Oliva said that only California is getting more money than the lawyers. But that's sort of if we're going to use litigation to shake things up, and if we're going to use it as ex post regulation, then that's sort of the cost of it, right? We have to pay the people who are going to do it.
Oscar,
Yes.
what's your reaction to this from your broader global perspective?
Yeah, I have, of course, there is costs associated with litigation. That's why I was trying to frame what we've seen more, that it's used more widely now. It's constitutional based litigation that use specific expedited procedures that are less costly. I mean, it's an easier type of litigation to try to carry forward. However, we do have also kind of healthcare recovery litigation going in some countries. And one big piece here that is also private funding that played a role, for example, on tobacco control, is all of the investment that Global Philanthropies has made throughout the world, right, on legal issues around tobacco regulation. So I think there we can see foundations playing that role to really try to put in the resources necessarily to use litigation as a tool, but also something that we cannot escape in the context of even regulating this unhealthy commodities is defensive litigation. I mean, if governments are successful, if the regulatory agency is successful, if the legislature is successful, corporations are going to bring massive litigation on their end. So what has happened is that the capacity to litigate has been kind of constantly supported through a lot of these private foundations. And sometimes it was mainly to be defensive, but now it's been turned to be how we can use it in a much more proactive, offensive way as well. Yes, I'll stop there. Yes.
I'd like to call on Jennifer and then maybe Maria to react.
What's the question?
Well, you were just saying that
Yeah.
These issues about also the federal aspect of this and how the role of the federal government in undermining some of the achievements and whether, in a previous panel, there was a discussion of, this whole thing is broken, and we really, and I don't know what, Maria might, I think, have something to say about this, but we really need like a strong regulatory approach to all of these questions. And that gets into the politics of federal regulatory power. So, you have some comments in the chat. I was hoping you could share them with the group. And
oh, sure. I was responding in the chat, so I'm sorry I wasn't responding to Maria's question in the chat there at the end. The federal government really can play a big role here by repealing this 1970s structure that does treat OTPs very differently than any other sort of gold standard medication for any other condition or disorder. The regulatory structure there really hinders access to services for people. They also, people have begged, and the Biden administration has made moves on this, but to get rid of these, the Data Act waivers and all these extra steps that folks have to do in order to prescribe these medications or have access to them. We heard yesterday, and this has been a longstanding problem, the federal government has refused. This has been a fight for multiple decades about funding syringes. There's been a limitation on that we've had some change, announced regulatory change on that recently. That could go a long way and really help. So we have these evidence-based services that have been highly stigmatized and over-regulated that prevent treatment providers from easily delivering them. And this is particularly problematic in rural states where you could go hundreds of miles and not have a service provider because of the sort of arduous nature of regulatory compliance in this context. So that's what I was trying to respond to, is that one thing that would be wonderful to see here is the lifting of the federal and state regulatory structure that really hinders access to evidence-based treatment.
Thank you so much. I see that Zach has his hand up. Maria, do you want to jump in, or should I go to Zach?
I'm happy to come in now, or I think I'm also happy. Zach, why don't you come in, and then I can come in after that.
Sure. I was going to say, certainly on the point of regulatory reform, to sort of endorse what she's stating, but also it's also very nuanced, because the different, there's not any, even on our side of things, the patient advocacy side and or the treatment side, there's not consensus on the X waiver for buprenorphine. Most patient groups support it because they feel they have a right to have access to trained providers with at least the most basic training, whereas there's also good arguments about getting rid of it. So the regulatory structure is very complex, especially around OTPs and such. But some of them are there for good reason. When the methadone trials first started at Rockefeller University in New York back in the late 50s, methadone was offered outside of a structured program. And what we had at the time in New York was the hospitals were overrun with methadone toxicity, and diversion was rampant, and it was everywhere, which is part of what created some of the stigma we're still fighting when it comes to methadone. That and just a really vast expansion of the network, faster than we could train people to understand how to best provide it. And so the concern about just, yes, we treat this differently than some other medical treatments, but it's also a different disorder with, psychological, spiritual, social and medical, biological. It's a very complex disorder. But if we just start prescribing methadone again, as we saw from the pain clinics when they did in the early 2000s, when the methadone deaths ticked up. So it's important we have some regulation as that ensures patient safety, and that ensures we don't do ourselves in, or we don't use these tools that are great tools and necessary tools, our best tools to confront the crisis, in a way that we then create another problem, or we further stigmatize MAT. And that sort of piggybacks on what we talked some about yesterday, where, the medications are important, but we have to have a system wherein people have access to comprehensive services for the myriad of other things that they present. I know Congressman Norcross out of New Jersey has got a bill that's going to be introduced soon that would seek to reform some of this. I know our colleagues at SAMHSA are looking to do some rulemaking on some of the more arbitrary stuff in the opioid treatment regulations. They control. But I just wanted to make the point that it's very, very nuanced, and we need to reform, but we've kind of devolved into this hashtag situation, which leaves out a lot of these important points. So I just wanted to put that out there for a point to consider.
Yeah, and I appreciate those. I did want to respond to that really quickly. I just think that most Americans don't realize how much more difficult it is to get treatment for opioid use disorder than it is to be prescribed a Schedule II opioid. You don't have to jump through any of those steps to prescribe a Schedule II opioid. You do have to jump through a whole bunch of steps to prescribe a Schedule II or Schedule III opioid agonist or treatment, and that is a very, very unusual regulatory structure.
Right. Well, and we see what it got us. We see what
there you go.
The former got us.
So we have a bunch of hands up. I'd like to just ask Professor Glover to respond, and then I'm going to call on Dr. Clark in our last few minutes.
Yeah, so trying to synthesize so many important and nuanced and complex points, I think sort of as a 30,000 foot up matter, we've done a lot of discussion, sort of inter-settlement, as it were, like how do we work within the settlement? How do we make sure that settlement says what it needs to say, delegate to who it needs to delegate? But neither litigation nor settlement and the regulation that it effectuates, it occurs in a vacuum. It exists and will be operationalized against the backdrop of our system of federalism and states with multifarious and often conflicting regulations and laws, and not just conflicting with one another, but conflicting with the priorities and the goals of the settlements. And so when we talk about how states can constrain the spending, which has been a huge focus of this conference and connects to one of the deliverables from this conference, namely the model state law, there's a bigger point about who constrains or guides or enables the states that are supposed to constrain the spending. And that's why I asked my question about the role of advocacy. In terms of things at the federal level, I'll first express that I'm relatively pessimistic in as much as, and this is, I hope not too in the weeds, nerdy technocratic law point, but it matters. As I tell my students, this stuff matters. Part of the reason we struggle to resolve mass harm generally is we don't have much ex-ante regulation. And even in ex-post litigation regulation, we don't have national products liability law. We do not have federal consumer protection law. We have a patchwork of often conflicting state laws that prevent often consumers or other citizens harmed by the same product in a national problem from joining together in a joint litigation simply because the state laws conflict. And in 100 years of that problem, largely since the court decided Erie back in 1938, Congress has not really, I'm just going to say, they haven't bothered to do anything about it. So I'm relatively pessimistic that we would get a substantive statute that might create some uniformity and prevent the hurdles that come up state by state. But I'm also, maybe I'm glad about that, because the statute that Congress would write would undoubtedly be awful. Sorry. So what can we do? My thoughts on this are perhaps there are many nuances that we would not want to be dictating from the federal level, because as Zach said, that wouldn't address the various complexities as you get down into different requirements. But what if there were some operational things we could agree with and lobby for in terms of federal legislation or federal guidance? Say something in the Affordable Care Act that prohibits non-coverage for medical assisted treatment. I hate to bring in, I don't want to bring in this topic for purposes of the conference, but looking at the problem of, for example, reproductive care and abortion clinics, is there something we could all agree on that there need to be some critical mass of certified treatment and recovery centers per geographic area or per capita? If we could agree on fundamental principles that get at some of these barriers to treatment, barriers to recovery, it would seem that by virtue of this being a national epidemic, right? This isn't a Tennessee epidemic, it's a national epidemic, that there is room for advocacy at the federal level to achieve uniformity, because as much work as all of us want to do within the settlements and in the distribution of the settlements, again, they exist against the backdrop of federalism, multifarious state laws, and judicial doctrine that does not allow us to supersede those state laws unless and until there is some sort of federal overlay.
Thank you so much for that. I'd like to ask Dr. Clark if he would just, we only have 2 minutes, but if you could share with us your thoughts, Dr. Clark, and then I'll thank the panel. This has been really fantastic. Please.
Okay, for some reason, my video is disabled, but I think to build on what Zach was saying and to build on what Maria was saying, the polarization of federalism is an issue. We are not just dealing with the pharmaceutical companies and their networks of suppliers. We're also dealing with providers and community attitudes. The Controlled Substances Act was born of community attitudes, and we have to deal with that in addition. Since the Controlled Substances Act and the international conventions that issued from the Controlled Substances Act. So we're dealing with multiple jurisdictions and multiple policies looking at the issue of psychoactive substances. And finally, when we look at things like access to care, we have 12 jurisdictions that are non-Medicaid expansion states. And I can't find anything in the Support Act that would compel the non-Medicaid expansion states to extend treatment to those who are not eligible for treatment, as the Medicaid expansion would permit. So these are themes that are more global and atmospheric that we are dealing with as we move beyond the framework for the current litigation. We've got a lot of attitudes that we have to change and a lot of mulling over that we have to do, because we're dealing with a societal issue. As I tell my students, why do people use psychoactive substances? And if we can answer that question, we might be able to come up with a more coherent approach to this problem. Thank you.
Thank you so much for that. And thank you to our fantastic panelists. I feel like I learned a ton. I still want to interrogate Oscar more about the South American system, but we'll have to do that offline another time.
Be careful with interrogation in South America.
Yeah, well, only no enhanced techniques, Oscar, don't worry. All right, so I'll turn it over, I think, to Maria now, because our panel is done. And again, I just want to thank the panelists for really enlightening and interesting comments, and our participants as well. Thank you so much.
Thank you, Alexandra. Thank you, Teddy. Thank you, Professor Oliva. Thank you, Professor Cabrera. Fantastic end to the day. And also, I think, crystallizing in a way of two key takeaways. There are many takeaways from this conference, but two key takeaways from this conference are, one, the inner workings of the settlements themselves, the representation in those settlements, the voices in those settlements, the delegation of authority, the structure of those settlements, the inter-settlement governance. But then there's a second point, which is the framework and backdrop against which these settlements necessarily will operate. The settlements, I can assure you, just having, based on what we all know, we hope for much better than tobacco, but the settlement and their effect on the opioid epidemic will be good in a lot of ways, and it will falter in a lot of ways. And that's on the settlement itself and the people entrusted to its management. But at some level, the operation and impact of these settlements is only as good as the framework and backdrop and regulatory apparatus against which that settlement operates. And we've done a lot in this conference to generate ideas, strategies, innovations, to put together for how we can best impact what's in these settlements and get the right people in the right rooms putting together the right plans. And that will be not just now, but continuing through the settlement's future. But I think this conference also brings a very stark light on the fact that we also have to be very attentive to and seeking to impact where necessary the legal frameworks, the regulatory frameworks against which the settlements are going to operate. And we've identified some key pressure points that, at least in some states, could prevent even the best settlement and the best settlement managers and the best judges and the best state actors from having much of an impact. So those two key takeaways inside the settlement and the framework against which the settlement operates really come out as two big takeaways for me. That does bring us to the conclusion of this conference. So I want to emphasize not the conclusion, I hope, of these discussions, these strategies, these cooperative sessions, this cooperative advocacy and brainstorming and strategizing, all in service, as we said from the very beginning, of maximizing the litigation and settlements to save lives, to rebuild communities, to fight this epidemic. That's sort of the broad strokes. There are some very specific actionable things that come out of this conference and that we will be sharing with you as we gather post-conference materials. The participants and attendees, I feel like none of our work is done, but for those of us hosting the conference, I can say for certain our work is not done. And I want to turn it over to Shelly Weizman, again, my right hand, my left hand, without whom this conference would not have been possible and would not have been the success that it has been, to talk a little bit about where O'Neill, Georgetown, Pew, LAPA, and the host of this conference, where we go from here, and I hope where we go from here with communication with you and interaction with you.
Wonderful. Thank you so much, Maria. And thank you everybody who has joined as panelists, as folks listening in, participating in the chats and the conversations. And I know that this is the day in and day out work of many folks who've been involved in this last day and a half. Like we talked about yesterday, I think we're really focused on not just having this conversation and then everyone goes back their separate ways and it's as if it never happened. We're very kind of hyper-focused on developing actionable strategies for implementing some of the work that we've discussed in these last few days. And what we really know is looking forward, right? And this has been the conversation in a lot of the panels today, and of course yesterday as well, that the devil's in the details, right? Developing mechanisms at the front end to in settlement language, in state legislation, in these MOUs, and in implementation, right? And this kind of long-term strategies, perhaps over 18 years, and what that might look like. So as we've been going along, I've been kind of ticking off a working list of potential products, strategies, outcomes that can come out of this summit. And of course, more to come. We're going to be pulling together what I think I've been calling in my head, and maybe this is what we'll end up calling it, like an after action report that we're going to be publishing in the coming weeks. That is basically all of the themes and strategies and tools that have been discussed in the last day and a half. And in addition to that, some other specific products that we hope can be tools for advancing and maximizing the use of these litigations funds. Of course, as we've discussed a great deal over the last day and a half, model state legislation that dedicates these funds that we hope that states can take and really adopt as one tool of probably many that is going to be needed in order to maximize funds going forward. That I think will be released here in the next few weeks. We're targeting at least the end of October for that, but hopefully sooner. We've also had a lot of discussion, as Maria just spoke about, post-litigation governance structure and what that might look like. a model for a centralized coordinating body or point person to coordinate all of these funds that are going to be invested, not just from litigation, but from federal and state government. We've talked about potentially a model for a council that is independent, but also has teeth and certain authorities, taking lessons learned from HIV and other kind of policy areas. We've talked about a 101 for advocates and other stakeholders about the litigation, and how that is a necessary mechanism to support this feedback loop between the advocacy community and folks that are administrating and making policy decisions, both in the litigation and in government. We've also talked about a mechanism for support from the federal government on aligning funds, on advancing best practices. Would that be a monitoring function? Would that be an incentives function? What's happening now? What's envisioned in the future? And we've also discussed potentially a central repository for what's happening in each state, so people can just share ideas and not reinvent the wheel in our little silos, and including how states are innovating. Those are the things that I've ticked off on my little list here. And I'm sure that there are others. So when we kind of go back and regroup and probably re-listen to these last 36 hours, I think more will come of it. If folks who are listening in have ideas or priorities, or think, here's something that I think would be a really important strategy going forward, please share. I think also, it goes without saying, but I will say that many folks on this call are working on this issue and have developed and are developing kind of complementary and parallel tools. And we don't want to diminish that. We don't want to, start from nothing, right? We're starting from that a lot of work has been done on this, and how can we, as a convening body, as a where we sit at the intersection of law and public health and policy, really advance what needs to happen here. So much more to come. I want to sincerely thank everybody. I know that it was a very early morning for some of you, particularly on our 9 a.m. panel and folks on the West Coast. And this has been just tremendous. And thank you to Maria. I've loved this partnership in really kind of marrying law and public health and the litigation side of the house, which I haven't been extremely exposed to. So with that, I'll turn it back to Maria to close us out.
Thank you so much. And as we go forward with some of these specific things and these deliverables and memos, I want to reiterate what Shelly said, that this is a convening body. And the people we asked and so generously accepted our invitation to come, we asked because you are doing the work, because you are experts, because you have done the work, because we wanted to convene all this wisdom and devotion and work that is happening all over into a unified body where we can share our understanding, share our perspectives, share our work, and learn and grow from one another and develop more comprehensive and informed approaches when we all go back to our own particular silos. And this marriage, as Shelly said, of law and public health could not more aptly describe what this conference tried to do, with an eye especially toward the particular public health problem we have and the people who are most affected by it, those suffering from addiction, those who are in recovery, those supporting family members in this situation. As we put some of the materials that I hope represent and reflect this shared wisdom and shared knowledge. I hope that any and all of you, whether you're on now or participated yesterday, will please reach out to us in service of, I hope, creating a collective body of information from which all of us can draw as we continue to advocate in this area, as we continue to work in this area, and as we stretch out into, as we said, inevitable public health and litigation intersections. in the future. And the O'Neill's Institute and I will do, and Pew Charitable Trusts and LAPA will do our best to synthesize and collect that shared wisdom for the benefit of all. Finally, I just want to conclude by saying a most heartfelt thanks to every single one of our panelists, all of our moderators, many of whom were panelists, to our incredible team who pivoted from an in-person conference to a tech conference, which I have to say largely went off without a hitch. So Kyle and Max, Summer, Melinda, Melissa, Sonia, all of them are just made the magic happen. I'm deeply thankful and indebted to our amazing sponsors who have not just been supporting us financially, but have been there every step of the way in the planning and the strategizing. So Pew Charitable Trusts, Beth Connolly, LAPA, Susan Weinstein, and then Georgetown University, which also backed this conference. This has, I hope, been thought-provoking, generative, enlightening, at least for me. I've never been to a conference where these many divergent views and perspectives and as I said, collective wisdom has been brought together in a dynamic and strategic way. And at least from my vantage point, this is one of the most professionally rewarding conferences I've ever had the honor to be a part of. So thank you, everyone. I hope all of you have a wonderful weekend. And again, not the end, stay in touch with us. We'd like to work collaboratively with you in the coming months. And if anyone has any questions about getting access to materials or anything, feel free to reach out to us. And thank you so much. And let's go out and try to maximize this to save lives.